Okay. Hello. Good afternoon and a very warm welcome to everyone. On behalf of THAKUR RAMNARAYAN College of Law, I, Shweta Yadav, would like to thank you all for joining us on today's guest lecture, which is scheduled on the topic Broad Outlook on Rera. We really appreciate you all for taking out the time and being here with us today. It is a great pleasure for me to introduce our eminent speaker for today's guest lecture, Advocate Shruti Desai ma'am. Shruti Desai ma'am is a brilliant professional with over 30 years of experience in the field of property law and real estate.
Shweta, just a second. You are on mute.
Okay, so sorry, so sorry. Okay, I'll start. Hello, good afternoon, and a very warm welcome to everyone. On behalf of Thakur Ramnarayan College of Law, I, Shweta Yadav, would like to thank you all for joining us on today's guest lecture, which is scheduled on the topic Broad Outlook on RERA. We really appreciate you all for taking out the time and being here with us today. It is a great pleasure for me to introduce our eminent speaker for today's guest lecture, Advocate Shruti Desai ma'am. Advocate Shruti Desai ma'am is a brilliant professional with over 30 years of experience in the field of property laws, laws relating to octroi, municipal laws, opinions on subjects like stamp duty, handling litigation on various subjects of law, RERA, DRT laws, financial laws, company laws, real estate, arbitration, and mediation. Ma'am is a well known consultant on civil laws, property laws, inheritance laws, banking and finance, contracts, vetting of contracts, retail chain agreements, and e market retail chain agreements. Furthermore, ma'am has handled various issues under RERA, such as issuing notices, drafting complaints, and arguing before the authority. Adding to this, Advocate Shruti Desai ma'am has authored 22 titles on property laws and all are university recommended. Ma'am has drafted various types of documents to name a few: agreements, conveyances, gifts, redevelopment agreements, tenancy agreements, settlement deed trust, AOP, partnership deed, power of attorney, wills, indemnity, and so on. We welcome you, ma'am. Before we start, I would like to inform the attendees that they can type down their questions in the chat box given below. Also, all participants are requested to keep their mics on mute so that there isn't any disturbance caused in the session. Now, without any further ado, I request ma'am to begin with the session. Ma'am, the floor is all yours. Thank you.
Thank you, Shweta. I thank RAMNARAYAN College of Law to give me this opportunity to speak on this subject. I also thank Dr. Anil Kumar Singh, Principal and Chairperson. I thank Mr. Jitendra Singh, Ms. Secretary, faculty in charge, Mrs. Urmila Chauhan and Ms. Bhumi. And to start with, Real Estate Development and Regulation Act 2016. It came into effect in the year 2016, but after a wait of 11 years. The name of the act itself suggests that it is a regulation for the development of real estate. Now, why do we need this law, or when we have laws like MOFA, Maharashtra Ownership Flats Act, Transfer of Property Act, Contract Act, and on the Specific Relief Act, etc. The reason was at the request of various quarters for many years. This was an issue which is pending for long period of time. Lawmakers were discussing about the same something like real estate regulation for 11 years because the buyers across the country are agitated rightly as they are not getting an adequate redressal system as per the previous arrangement. Now, at the time, today's vice president was then urban development minister. At the time of placing this bill on the floor of the parliament, on the table of the parliament, he said, it is in his word, he has said, why do we require this law? This act seeks to encourage both of them to live up to the expectation of each other as per the agreement entered into by both of them, that is the promoter builder and the flat purchaser. When you purchase a house, you enter into an agreement. If one of the party fails to perform the obligation, then provisions of the act will come into operation. If they mutually agreed upon, nobody is going to intervene. Unfortunately, what is happening is that the buyers and consumers are always at loss. In India, the law of tort is very weak as compared to other Western countries. We do not have such provisions to enforce law. He said, this is not my words, this is the word of the then UD minister. I'm not here to accuse judiciary, but the judicial system as of now in India today is such that we are not able to get speedy justice. So the helpless consumers and consumers should not be left in lurch. If you travel from Borivali to Churchgate, you will see so many properties on which there is a board, a court receiver, High Court Bombay. Somewhere it is written 1965, somewhere it is written 1976, and the owner and the flat purchasers and the builder, they generation after generation have passed, but the problem is still there and it was not resolving. So this law was put up. This law seeks to establish a regulatory authority which will with which the developer will register his project. I remember during olden days when I started my practice, and thereafter so many conveyances we had done. At that time, we used to send search clerks, and from Borivali, Kurla, Thane, Mumbai, and everywhere we had to search all the documents. But most of the time, we used to get answer, papers torn, no document is available, there is no record. So this was one of the problem and major problem for issuing certificate of title. And after issuing of certificate of title, if there is any adverse claim, then the solicitor was responsible for issuing such, a doubtful certificate. So this is a very good platform for even the buyers and the professionals to get handy information about the title of the property, the plans, the IODs, CC, at what stage it is, who has given the loan, everything is under one roof. So it was mentioned in the court that in the parliament that if X wants to launch a project, he has to register it with regulatory authorities. It is that simple. Secondly, while doing so, he will have to declare all the project related information, including the details of developer status, land, various approvals, projects, schedule, information regarding architects and structural engineers, etc., so that there is a transparency and people get satisfied when they come to know who are the architects, who the developers are, who are the engineers, and the size of the projects. All these things will be in public domain. Thirdly, the disclosure helps the home buyers to make a choice. They can decide which home to buy, which developer they would like to go, who is the architect. Sometimes architect name is also very important. So consumers has a ready platform. They don't have to hunt all the departments of the sub registrar, and then you see that if the papers are torn, there is no index, nothing was there. So they were trying to maintain it. I will not say nothing was there, but most of the time we used to get torn reports. Now, apart from fair play, the real estate transaction also aims to timely execution of projects. There are so many projects redevelopment projects in Mumbai we come across, which are not complete even after 10 years. And the flat owners or the tenants who have signed the agreement with the promoter builder, they are still on rent and there is no future. So sometimes we advise our clients to take money and buy a property or a flat which is in ready possession, which has IOD, CC and completion certificate along with occupation certificate. So this is one of the problem. Even today, this is a problem, but RERA is trying their best to resolve this problem. Moving further, timely execution, as I said, was a major issue. People do not respect the time. And as a result, there was a cost escalation. There are so many properties here in Mumbai. There is a cost escalation. Suppose it would have completed in 2 years, the cost would be 1 rupee. After 10 years, it will be 100 rupees. So there is a lot of escalation, and there are, you must have read that even RERA is dealing with such a situation. Most of the time it is settled before RERA, but before that, if you file a suit, you have to wait for 25 years, very, very long period. People, moving further, keep it in mind, it ensures timely execution of project. During this pandemic, we have seen the extension of time, and it was granted on the basis of on the basis of the situation which was there, and all the RERA, the handing over the possession deadline was extended by RERA, and many such disputes were resolved. Before it started, it was resolved because the time period of possession was extended by RERA authority by a common notification. Now, Vice President today and then Urban Minister said while presenting the bill that it seeks to provide uniform regulatory environment and orderly growth of real estate sector. As the government wants the real estate sector to grow, the real estate developers are also partners in development. We do not consider them as untouchables. Some people have the habit of condemning the private sector. We who are in the government do not believe that the private sector is bad. The public and private partnership is need of the hour. That is the way forward. We have seen the other methods in all these years. Then we have learned by experience that that is the way we have come to this conclusion. Now, this act was made and it was passed in Parliament and it is in force today. Now, we will see the nutshell features. It has the real estate industry is very huge. Now, inflated prices of residential houses, even educated class sometimes find it difficult or for years together to own their dream house. To own a small house, in fact, is a dream, at least in Mumbai. An increase in the cost of houses, multiple taxes on a house will certainly increase slums. Builders were selling super carpet areas, free flower beds, and all other facilities which were free of FSI. So they don't pay to the corporation, but they charge the flat buyers. So the cost is, suppose 1 rupee and your area is, say, 80 square feet, they charged for 100 square feet, considering it as a super built up area. And there was no uniformity in selling the area or calculation of the area. This is one aspect, and we have now, with this act coming into force, the area is carpet area, which is to be charged by every builder. So if your builder is charging otherwise than carpet area, then you can complain to the RERA authority and you can get the price reduced accordingly. Even in redevelopment projects, after demolition, old members are remediless or have to wait for years together. It's a real, I have seen this situation for so many years, and even today, the redevelopment projects are really, problem, and I, urge to the corporation and the lawmakers to do something in this, because the committee of the society is a private member, and the builder and they are professionals. So there is certainly a problem, because people, then they have to live on rent. Sometimes they don't get rent from the builder. Sometimes it is 10 years. There are so many projects, even I know, and I'm aware of it. And people go through a lot of tremendous mental pressure, financial pressure, and they are homeless despite of having a home. So I think this RERA will help to reduce such kind of incidents. Now, why these things, why we have seen that in my 30 years career, uh, one flat is sold to 10 people. Because I tell you why. Previously, there would be a printed format. They would print the promoter and buyer's agreement, and they take signatures of the investors. See, they take money on loan on any of the flat or the property or whatever it is, and they don't register it. They register, suppose XYZ have given loan on flat number 1, 2, and 3. So there may be 3 or 4 agreements which are neither adequately stamped or registered, but it bears the signature of the investor. Now, what happens? Investor and the promoter. One copy is with the investor. If he doesn't get his interest or the principal amount refund, he would go and register the document. Now the catch is, here the builder would have sold a same flat to a prospective genuine buyer. So the genuine buyer doesn't even know he has taken loan from the bank. He doesn't even know, because those agreements were not signed, not registered. So there was nothing on record, official record, that flat number A, B, or C is sold, or there is any mortgage. Nothing was there. This was a cash transaction. So now the genuine buyer who has collected all his hard-earned money and taken loan, he is in trouble, and he had to face lots and lots of problems. Anyhow, now with RERA, we get everything under one roof. You go on RERA website, whoever is your promoter builder, you have to put the name of the promoter builder, or you have the details of the property. You have to put the name, the details of the property. You will get everything under one roof in one website. This is one of the biggest advantage of RERA. So this lack of information to the gullible flat buyers. There were one flat which is sold to 15 people, and the scenario in the court was very pathetic. To overcome this situation, government enacted this RERA Act. Every person who wants to buy a house will get information on national portal, along with the sanctions about all properties in India. A separate and exclusive court, that is Real Estate Authority, is set up for hearing of grievances with all the powers under CPC. And the time limit is framed. This will extinct the element of cheating and fraud. Strict provisions are made for violating builders of deregistration, cancellation of registration, debarring them. Not only builders, even the agents, the estate agents will have to register their name and details with the RERA authority. So there was also a dispute. You have not paid my brokerage. So this will not come. Now, if you are not a registered broker, you cannot ask for brokerage. In India, maximum litigation entered in the honorable court is with respect to the land. Now, it's a say, I'm not saying this, it's a say from so many years, hundreds of years, that why there are litigations. So in Gujarati, it is said that, jar, jamin and joru. That means wine, woman and wealth is the reason for every litigation. So we have to be very careful when we practice wine, woman and wealth. 3 W's, you should be very careful. So I am a woman. There are several acts like Land Acquisition Act 1894, the Indian Registration Act 1908. From inheritance to transfer and transmission, there are various acts which govern the title of the property, especially in Mumbai, where land is less and density of population is very high. Here in Mumbai, the per square foot rate for residential premises ranges between 5,000 to 1,50,000 approximately. 1,50,000 if you go to South Mumbai. It costs so much. The builders were selling one flat to multiple purchasers, and have also seen the builders creating equitable mortgages, which I said, on a flat with multiple banks, because banks were not aware. There was no centralization of information. And by using printed agreements, which I discussed, there was no proper index, even when with the bank flat or how many flats are sold, how many flats are unsold. There was no details available with anyone. Several litigations are still pending after decades of introduction of Maharashtra Ownership Flats Act 1963. The same was the condition in other states, and hence government introduced a bill and enacted the above act, which controls and regulates the development, construction, and sale and management of all the properties across India. Now, what does a preamble? Preamble is the intention of the legislature to make any act. So, preamble of this law says, the following Act of Parliament received assent of the President on 25th March 2016 and is hereby published for general information, and Act to establish Real Estate Authority, Regulatory Authority for Regulation and Promotion of Real Estate Sector, and to ensure the sale of plot, apartment of building, as the case may be, or sale or resale of real estate project in an efficient and transparent manner, and to protect the interests of customers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also established appellate tribunal to hear appeals from the decisions of the real estate regulatory authority and the adjudicating officers, and for matters connected therewith for incidental thereto. So this is intention of the Parliament to enact and enforce this law. This law applies to entire India. In August 2020, Jammu and Kashmir notified its RERA rules, and the Union Territory is now bound by central rules. Although it does have the authority to draft and implement specific rules with respect to local situation and laws, Ladakh too notified RERA, and so RERA applies to whole of India. Now this section has, this act has 92 sections and 10 chapters. Today we will focus mainly on 2 aspects. Because as a student, you will have to learn the entire law. But when you practice, mainly you have to see what are the rights and duties and obligations of the promoter and his liabilities, and also rights, duties, and obligation of the flat buyers. Take note of it that flat buyers also have obligations. They cannot run away from the agreement on any count. So both the parties have its own obligations and rights. So we will discuss, because time is only 1 hour and 92 sections. We cannot discuss, very far we cannot go. So whatever is the important, I will just narrate in this 1 hour's time. Now, what are the main features of this act? No promoter shall advertise, market, book, sell, or offer for sale any plot, flat, or building without registering the real estate project with real estate regulatory authority constituted under this act. The next one is the present act is applicable to ongoing project. There is also a judgment on this. There was no need to go to court because this provision is already there. So applies to ongoing projects which have not received completion certificate on the date of enforcement of this law. So when this law came and you have not, the project is not complete, the promoter has to register his project with Rera. If your project has received completion certificate, then it is not required. On the date of, and this is because on the date of enforcement of this act, there was a confusion, but I don't see any confusion because it's part of the act. And it is already mentioned that ongoing projects which has not received completion certificate will have to register the project with Rera authority. On the date of enforcement of the present act, if there is a construction beyond the planning area, that is, suppose you are permitted only 5 floors and you have constructed 6th floor or 7th floor, which usually happens, but with the permission of the local authority. Suppose your FSI permission is only of 5 floors, but purchase of TDR takes time. So 6th and 7th floor usually builder constructs and awaits the purchase of availability of TDR and loading of the TDR on the project. The authority under this present act may order such development project for registration. So such projects are also requires registration. Now there are exceptions to this act. The Rera Act doesn't apply to whom? Let us see this. Where development of land does not exceed 500 square meters or 8 apartments, inclusive of all phases, are exempt from registration. So if a project is say 490 square meters and 7 or 8 flats, then it doesn't require registration. So then what happens to such project? MOFA applies. So the buyer of such project will have a remedy under Maharashtra Ownership Flats Act. Now, I had written one book. It was a self-published book, and following questions were raised in this very first edition of mine. Section 3(2) of the Act exempts any project which is under construction but does not exceed 500 square meters or number of apartments does not exceed 8. So the question arises, if it is exempted from Rera, then what applies? Then I said MOFA. Now, the problem is what to do. The question is answered by Maharashtra Rera Appellate Authority in Gitanjali Aman Constructions versus Paranjape and others. In paragraph 58, I will read the gist of it because we are short of time and the law is very vast. Considering the object of the RERA to regulate and develop the real estate sector, to protect the interest of the customers in respect of transaction of sale of flats and real estate sector, and to monitor the activities of promoter and allottees in respect of such transactions, encourage promoters to complete the project in agreed time and to fulfill the dream of home buyers to get their home, the clause exception. Now, moving further, the conditions of the area of the plot and conditions of number of flats for getting exemption from the project are not mutually exclusive to each other, and both the conditions must be satisfied at once for obtaining the exemption from registration, litigation, and fraud. So, two conditions are not in alternative, but it is conjunctive. That is what the appellate authority has said. This order in Aman, Gitanjali Aman, was 2:1. And there is no further, to my knowledge, there is no further litigation in this. So we would wait for clarification on this aspect. Another exemption is where promoter has received completion certificate, which we have already discussed. Renovation or repair or redevelopment, which does not involve sale, marketing, advertising of any flat, plot, or building. So where there is no sale, no public money is involved. You have not taken money from the flat buyers or the banks or any other investor, but it is a self-funded project. Then there is no registration required. So basically, this is to protect the interest of the banks, to protect the interest of the public money, the public flat buyers, the bona fide purchasers. So this was the intention which we already discussed when what was discussed in the parliament at the time of putting up this bill on the table. Now every phase has to be considered as stand-alone project. It means that if first phase is over, completion certificate is issued, and the builder has handed over possession and occupation to the flat purchaser, he need not register such a project. But nowadays we see a huge township. So if there are any balanced building on the date of enforcement of this act or thereafter, then such project in phase manner, how many buildings are there, how many wings are there, how many floors are there, how many car parking is there, what is the open area, what is the common facility, everything has to be put up in the on the website of the RERA. So now how to apply, how the builder has to apply. Every promoter shall make an application in the manner provided, accompanied by such fees. It is provided in the rules. You can get on the website of any state RERA. Application must be registered along with details of enterprise, the partners, the company, the AOLs, whatever is the case may be, registered address, names of the partners, names of the directors, nature, particulars of registration, photographs of the promoter, brief details of the project launched by him in last 5 years. This is also a very important point. An authenticated copy of approvals and commencement certificate from the competent authority obtained under the law. Sanction plan, layout plan, specification of project or phase, and whole project as sanctioned by the competent authority. Plan of development works, proposed facilities to be provided thereof, including the firefighting, drinking, emergency evacuation, use of renewable energy is also required. Location details of the project along with the boundaries, pro forma of allotment letters, agreement of sale, the number and type of carpet area, apartment for sale, project along with exclusive balcony, veranda area, and exclusive open terrace areas of the apartment with the apartment, if any, the number and of area of garage for sale in the project, the names and addresses of the real estate agents, as I said, it has to be registered, if any, for the proposed project, the names and addresses of contractors, architects, structural engineers. See, now this is so important. This act is so huge and so much effective and useful. It really protects the interest of the public fund, and even it is good for the promoters. They don't have to lie because it is already in public. So tomorrow someone cannot say that you did not, you hide from us at the time of sale. But if promoter doesn't, by mistake or otherwise doesn't inform the RERA authority, then of course he is liable. A declaration supported by an affidavit which shall be signed by the promoter or any authorized promoter stating that he has a legal title to the land on which development is proposed, along with the legally valid document with authentication of such title if such land is owned by any other person. In my first edition, I had raised issue of universal parking, still closed garage, veranda, and flower bed. What was, as I said, builder previously did not pay the premium to the corporation because it was free of FSI, but areas were sold to the flat purchaser, and they were asked that you can subsequently amalgamate, you can remove this wall and amalgamate, and your flat will be huge. And of course, there was a loss to the exchequer of the government and the corporation. And so now Maharashtra Rera has come out with a circular that at 30th July 2021 about the same issue. What is the status of whether builder can sell this garages and still car parking or not? See, now first we will say that what the circular says. It says that open parking areas are provided free of cost. Uh, uh, it is brought to RERA, and whereas there have been disputes on the exact location of parking space vis-a-vis apartment. In view of the above, it is therefore felt necessary to clarify the situation. Open car parking areas are provided free of FSI. Promoters are not entitled to sell a lot open parking areas for monetary consideration. So if you are a flat buyer and if the car parking is free of FSI and promoter builder has not paid premium to the corporation and the government, he cannot sell to you for consideration. He has to give free of cost. So open parking areas, garage and conveyor, covered parking space should be specifically marked and numbered at the real estate project site in accordance and as per the approved sanction plan and tagged to the apartment to which it is allotted. And garage and covered parking space, when sold and allotted for monetary consideration, the type, numbers and size, as well as the place where such garage or covered parking space is situated should be mentioned in the agreement for sale, because it will be registered. Being entered into and the plan showing exact location allotment along with the particulars as aforesaid should be annexed to the agreement for sale. The above direction shall come into effect from the date of issue of circulars, and all the concerned authorities adhere to the same. See, going apart from this law, we have seen in the past what used to happen. Closed garage was, you can see in the old buildings, and after 80s or 82, closed garage were completely stopped. Corporation is not giving permission from 82. And there was, there are DC rules also. So previously it was 1967, and then there was in 84, there was some amendment, and then 91, and now we have 2034 development control regulations for Greater Mumbai. Now what happened? Closed garages were misused. See, cars have become very big now. Previously it was Fiat or Ambassador. Now there are so many varieties that car doesn't enter the closed garage because it's very small. So people started using it for commercial purpose. So government and the corporation took a decision to stop such permission, and they started with stilt parking. Stilt parking was free of FSI. But in courts, we have seen that for stilt parking too, builder has charged, issued some receipt or letter of allotment, which is not a legal tender, but it can be an evidence, of course, collateral evidence when you ask for money or file a suit. But this was a serious issue. And now it's very clear that if the FSI is free, then builder cannot charge. So when you buy, still to check on the RERA website whether it is free or it is paid. Usually it is paid because now we have first floor, second floor, third floor parking. So for construction cost, of course, builder will charge. But then free of FSI, if it is free of FSI and there is no construction cost involved in such things, then builder cannot charge, and be careful. Now, another is the land is free from all encumbrances. So builder has to inform that land is free of encumbrances. or as the case may be, details of encumbrances on such land is to be mentioned in the RERA website, and write title and interest and name of party in or over such land along with the details. This is very important. Why I tell you? See, a builder A, he enters into various development agreements, say with Mr. X for a property, Y for B property, C, then Z for C property. Now he takes loan. I'm speaking pre-RERA era. So what he does is he takes loan on A property, enters into agreement. So agreement is that third party right is created, and he goes to bank and takes a huge loan, say 50 crores or 100 crores. Now he doesn't use that money in A, but he used that money in plot B, which is another project. This rotation was very common in those days, pre-RERA era, and it led to so many complications and title disputes, and so many people suffered due to this, rotation of money, from A to B and B to C, and ultimately either A will get it or C will get it, B will never get it, or this was the situation. So with enactment and enforcement of RERA, this is a better, because if a promoter has taken loan for development, he has to put the details of each and every loan on the property and details of the bank and the amount. So it is very clear, because unless and until he repays, even if you are society's form, it is his duty to repay. It's not your duty to repay. Keep it in mind. So if you come across with such, there is a judgment also which I read yesterday, that if there is a loan on the plot for development of the property and builder has taken not repaid, it is he who is liable and not the flat purchaser. Keep it in mind. Now, for use of money which he has charged or collected from the flat purchasers, 70% of the amounts realized for the real estate project from the allottees from time to time shall be deposited in a separate bank account maintained in a scheduled bank to cover the cost of construction and the land cost, and shall be used only for that purpose. So what I said, that what builder used to do, project A, B, C, he took loan on A, utilized in C, he took, I think he would have paid the partial amount, and he took another top up, and he took, constructed B. So C will not get, because that top up will continue. So C is without home despite of the agreement, and builder has then thereafter no money. This has happened. It is not that I'm saying some story or a fiction. It is a fact. Provided that now the promoter shall withdraw the amounts from the separate account to cover the cost of the project in proportion to the percentage of completion of the project. So he has to notify the RERA that I'm withdrawing, and that is also not so easy. The architect and the engineers and the site in charge will have to sign. After their signature, it will go to auditors. Auditor will say, okay, yes, it is required. And chartered accountant will sign, and then the bank will release the fund. So those days are gone where A, B, C. It's a very smooth transaction now. Now it is further provided that amounts from separate accounts should be withdrawn from the promoter after it is certified by an engineer, architect, chartered accountant, as I said, in practice, that the withdrawal is in proportion to the percentage of completion of the project. The further provision is that promoter shall get his accounts audited within 6 months of time and every financial year by CA, and the withdrawal has been in compliance with the percentage and the law, and scheduled bank is to be notified about this. The another duty is that he shall take all pending approvals on time from competent authority. So no delay is permissible, because you have given undertaking to Rera authority that on this day I'm going to hand over the possession. So if you don't give possession, mind well, the promoter is liable to pay interest on every delay. There is a provision in the act itself. So he has to furnish other documents as may be prescribed by the rules, regulations, and such other information and documents as may be prescribed. The authority shall operationalize a web-based online system submitting application, which is already done. The time period of granting registration is 30 days. Under Section 5, which includes providing a login password for accessing the website of the authority and creating web page. Rejection and order must contain reasons in writing why the registration is rejected. No application shall be rejected unless the applicant is being heard. So that is our democracy and our constitution, that nothing should be done unless and until a person is heard. So here, chance of hearing must be given. If promoter is not getting chance of hearing, he has a right to challenge. Registration shall be valid for a period declared by the promoter for completion of project thereof. Otherwise, he has to extend, and for extension is also not so easy. He has to mention why the project is delayed. So there is a huge penalty too. So I mean, this see how far the real estate market is regulated, and law is really helpful to the flat buyers, even to the promoter. He has become competent promoter and no dilly-dally. The registration may be extended by the authority on any application made by promoter due to force majeure. I said that during the pandemic, RERA authorities have extended the time period for handing over possession, because situation was that everything was under lock and key, and people were not permitted to go out and work. So, of course, because there was a threat perception, and the pandemic was very lethal. So this has affected the industry, and the government has also declared monetary compensation and other financial benefits to the real estate authority. Now, the project is registered. Now, when it can be registered? Okay, now before going to revocation of registration, I just want to tell you that if the project falls for registration, it is not exempted, then, and the promoter doesn't register, and you have purchased flat, what happens? What is your remedy? And you come to know, oh, this is unregistered project. You see, as a gullible buyer or buyer, be aware. Despite of that, I've seen people not taking legal recourse or advice, and they just walk in and they sign the papers, which is not correct. You should always take opinion of at least one lawyer who is knowledgeable in this field. So this say it is 10 flats and 550 square meter of area of plot of land, and he doesn't register. There are two aspects. One, it is self-funded. If it is self-funded project, it need not be registered, despite of the fact that it is 10 and 550, and he has not taken money till the completion and occupation certificate. So this is the first aspect, that promoter doesn't take money from the flat buyers, and he neither takes a loan from any bank, but he constructs more than 10 flats or 8 flats, and the area is more than 500 square meters, say 550 or 600 or 1000 square meters, but it is self-funded, it is his money. And after completion of the entire project, he comes in the market and sells along with the occupation certificate. Then there is no need of registration. Point number one. Point number 2, despite of the fact that he has taken loan, the property is mortgaged to the bank, and area is more than 500 square meter, and the flat under construction is more than 8, then builder is liable under the act. And if you purchase a flat in such building or a project, what is your remedy if you don't get possession in time? Oh, now so this was the mandatory. I didn't check. There is a provision on the Maharashtra Rera website, every website, every state website, that you can complain to the Rera authority without paying any charges. You just go log into the website, and there is a caption, unregistered projects. There you can log in and put your complaint that this particular project and the promoter has taken money, and he has not registered the project despite it is required to be registered under the law. This is one aspect you must keep it in your mind when you deal with such cases, when you start practicing. So it is very important to know this. Now it is registered. Okay. Now, can this registration be revoked? Answer is in positive, yes. But on complaint, any flat purchaser or anyone connected to the buyer or suo motu, the authority comes to know that there is something wrong with this registration, can be revoked. Now, when it can be revoked, promoter makes a default. Promoter violates any terms and conditions of approval. Promoter involved in unfair practices, which means a practice which for the purpose of promoting sale or development of real estate project adopt unfair methods like false representation about standard or grade. He has affiliation with such and such institution or ISI mark, that mark is there for approval, which he does not have, or false representation, misleading representation. In such case, registration of the the project can be revoked. Now, registration cannot be revoked before promoter giving 30 days clear show cause notice. He has to be heard by the authority, and that is fundamental principle under our constitution. So these are the aspects. Then what will happen to funds, and what will happen to flat buyers? That it is before the Rera authority, and they will decide. We need not go into, because Rera is a very competent authority. So of course they will take care of the flat buyers. Now, upon lapse of registration or revocation of registration under this act, the authority will consult the appropriate government to take such action as it may deem fit, including the carrying out of remaining development work by competent authority or by such association of allottees, or in any other manner as may be determined by authority. As I said, authority is very competent. See, I must say that whatever we may say, BMC ये नहीं करता है, वो नहीं करता है, ये नहीं करता है, but officers of BMC knows each and everything, every corner of your building, though you may not have visited the office. They knows what is going on in your building. So we must appreciate our corporation for that, and officers. There is a further provision in case of revocation of registration of a project under this act. The association of allottees shall have the first right of refusal for carrying out of remaining development work. So now let us move further. What are the functions and duties of the promoter? The promoter shall, upon receiving his login ID, the proposed project under this field as provided, he has to enter everything, as I said. I will not repeat because we are short of time, and reputation is not good. So now his further responsibility under the act is promoter is responsible to obtain completion certificate, or occupation certificate, or both as applicable from the relevant competent authorities as per the local laws or other laws for the time being in force. Then he is responsible to obtain lease certificate. Suppose it is a collector's land, or it is in Mumbai, it is BPT. BPT and collector are the major landowners in Mumbai. So government is also, Maharashtra government is also, but in sometimes what happens, airport authority, it remains open, and there is an encroachment and slums. So this is a problem. I hope in future government and the Rera will do something on this. Majority of airport authority land is encroached. If you go through mainland subway and right and left, whatever are there, shanties and the construction, temporary structures, they all are airport authority land. Now, he is responsible to obtain lease certificate where the real estate project is developed on the leasehold land. If you are a collector land, you're buying a land, flat in a collector land, be careful, check everything, because it's a big liability, huge liability, and you have to take, when you go to sell the flat in a collector land, on a collector land building, you have to take many permissions. So it's not that easy to sell flat on the collector's land. There is a notification, since this is not a subject here, so I will not discuss to convert the leasehold collector's land into a freehold. Specifying the period of lease and specifying, he has to mention everything. Suppose it is of 30 years, 90 years, or 990 years, he has to upload the lease agreement too. And he is responsible for providing, maintaining essential services on reasonable charges till the taking over the maintenance of project by association of allottees, that is cooperative society. So till then he has to manage the property, and he can charge the flat buyers till the committee is set up and the association of flat buyers or the society is formed. Now he has to enable the formation of association of society. It is his duty. He has to give account. That is a provision in the Maharashtra Cooperative Societies Act, and he has to form the committee and form the cooperative society. He has to execute registered deed of conveyance of the apartment, plot, building, as the case may be, in favor of allottees. Undivided proportionate title in the common areas to the association of allottees, competent authority, as the case may be, as provided under section 17 of the Rera Act. Now pay all outgoings until he transfers physical possession of the real estate project to the allottees or the association of allottees, as the case may be, which he has collected from the allottees for the payment of outgoing. See, I'll tell you what used to happen. Pre-Rera era, builder would collect 10,000 per each flat purchaser for formation of cooperative society. He never formed, and this money were never refunded to the flat buyers. So in those days, it was suppose 10 flats, it was 1 lakh, a lakh of rupees. And the cost of, in those days, say, the cost of formation of cooperative society was 25,000. So 1 lakh is gone, and the members would go and pillar to post, and they would register anyhow the society and take over the money. But benefits would never pass on by builder to the flat buyers. This was the scenario. Now the situation is different. Both the parties are very smart, and the laws are much clearer and transparent. After he executes an agreement for sale for apartment, plot, building, as the case may be, not mortgage or charge or any such apartment, he cannot mortgage after sale of, it will not happen as such now, because the documents are registered and it is available online. So this problem is not there. And the promoter may cancel the allotment only in terms of the agreement for sale. Now he can say that allottee has not paid, or he, he has defaulted, then he can cancel the agreement. The allottee has a remedy under the act, and he can, challenge the cancellation. And if, it sometimes happens that fail to pay the balance amount, so some it will be worked out before the RERA authority, or maybe refund may be granted, whatever is the case, may facts of the case. The promoter shall prepare and maintain all such other details as may be specified from time to time by the authority. No deposit or advance to be taken by the promoter without first entering into agreement for sale. This is basic concept. Just say, we used to give advances, earnest money deposit. Earnest money deposit is also laid down in the law, this RERA Act, and it cannot exceed that. So when you go to deal with such cases, keep it in mind that there is a provision for each and every act and action on behalf of promoter and on behalf of a flat buyer. So both of them must act according to the law, and any violation will, of course, their self-interest is affected. Adherence to sanction plan and project specification by promoter. Section 7 of MOFA Act. Maximum litigation I have managed and handled. Kalpita, from Kalpita to, there was no end. And it was 7 and 7A. Then it was amended. And MOFA, I'm talking about MOFA. And it was amended. And there are buildings in South Mumbai which are demolished too. So that is Tirupati apartment, if I'm not mistaken. So this has happened. And there was one building in South Mumbai where near Nehru Center, and it was of 21 story or 22 story, and all Bollywood top notch had entered into an agreement which was not registered. Some of them were registered and some of them were not registered. But subsequently, one night, a circular came that there is a height restriction around the Nehru Center, Worli, and all the top floors gone. What happens to the builder and what happens to the flat purchaser? Few of them were accommodated, few of them were, refunded. Most of them took their money and they walked out of the project. But there were people who challenged this cancellation, and litigation started that there is an amendment to the plan. Anyhow, this litigation is unending, but the project, I can see that it is completed, and I can see now the project is complete. So out of question, but this has happened. Overnight, there was a circular that there is a height restriction in this area. Worli, I'm talking about. Now, this is, of course, the amenities. Sometimes they say we will give this particular amenity of this brand, and it is not there. Then you can, of course, go to Rera, and you can say that he has charged so much for fit outs, and he has not given quality fit outs, or the wiring or whatever it is. Because nowadays we see so many fires in towers. So you should be careful about that. And now, obligation of promoter regarding veracity of advertisement or prospectus. We cannot even advertise unless the project is registered, provided he has taken public money. No deposit or advance to be taken by the promoter without first entering into agreement for sale, and he has to register. Registration of sale, agreement for sale is mandatory. Adherence to sanction plans and project specification by the promoter is the basic core nucleus of any agreement and the project, because he promises the corporation, he promises to the government, and he also promises to the buyer that this is the area, this is the project elevation, this is the plan, and he cannot deviate without the permission of the flat buyer, because it is his dream house and not promoter's dream house. So it is my dream house which I saw, and I purchased the flat, And if he changes overnight, sometimes what happens, he shows that there is outside window, there is an open space, and overnight another building comes up. This has also happened in South Mumbai. And after paying a huge money in South Mumbai, one fine day, I get up and there is a taller building in front of me. Instead of C, there is a building. So there was a litigation also on this aspect. Anyhow, now we have Rera, and of course, Rera Authority and Corporation will take care of such incidents. Now, any other alterations, additions, the sanction plan, they have to take permission of 2/3 at allottees. Any structural defect or workmanship, quality or provision of services or any other obligation of the promoter as per the agreement, it should be as per the agreement. The promoter, one has to complain within a period of 5 years if there is a defect in the construction. And they can approach, of course, the shall be entitled to receive appropriate compensation under the law as provided. Now, Section 15 of the Rera Act provides for the obligations of promoter in case of transfer of real estate to third party. This is very common in real estate sector. It is called financing and funding of the project. Suppose today I am constructing a tower, and at certain point of time, say due to pandemic, now I cannot complete, or I don't have funds, or I've gone bankrupt, whatever as the case may be, or I'm getting higher money, like my cost is say net income from this project is say 30 crores. But if I sell, my net income or the profit, I'm talking net, not gross, maybe say 75 crores. I will transfer my project, incomplete project, to third party. He will take over all my rights and he will undertakes to complete the project. In such case, what happens? There is a provision, and it is mandatory, that promoter shall not transfer or assign his majority rights and liabilities in respect of real estate project to a third party without obtaining prior written consent from 2/3 allottees, except the promoter, and without prior written approval of the authority. So he has to also notify the RERA. Now there is a provision: such transfer or assignment shall not affect the allotment or sale of apartments. Suppose I have purchased and it is sold to third party, say builder A to builder B. Now my builder is B. So what happens to my soul? Can builder sell my flat which is already registered and I have paid to A? No, answer is no. He is into the shoes of A, and he has to complete and accept my transaction, and he has to give my flat. Whatever balance it is my liability, I have to pay, but he cannot deny my rights and my flat. So this is another aspect. And assignment, on transfer of assignment being permitted, RERA will direct, of course. There will be direction by the RERA authority, and he has to comply. Both the parties has to comply whatever RERA says, and there will be a order that intending promoter shall be required to independently comply with all the pending obligations under the provisions of this act and pending obligations as per the agreement of sale entered into erstwhile promoter with the allotment. There is another provision in such case of transfer to third party during the ongoing project. Transfer or assignment permitted under the provisions of this section shall not result in the extension of time. See, it will not extend. The time of possession will be the same which is mentioned in the RERA website. Just because my lords, today only I received the brief, I need time to read. No, you should be prepared beforehand, and then only you enter into an agreement. That is what law says. There is no time extension of time. You take all the obligations of the previous builder. Now transfer or assignment permitted process shall not result into extension of time. Intending promoter to complete the real estate project and shall be required to to comply with all the pending obligations, so and so. Now Now, rights and obligations of the allottee. We'll go very fast now. The allottees shall be entitled to obtain information relating to sanction plans, layout plans, along with specifications of rules and made therein. The allottee shall be entitled to know the stage-wise schedule of the completion of project and water, sanitation, electricity, and other amenities between the as per the agreement between him and the promoter. The allottee shall be entitled to claim possession of apartment, plot, or building, as the case may be. An association of allottees shall be entitled to claim the possession of the common areas and declaration given by the promoter. The allottee shall be entitled to claim refund of the amount paid along with the interest at such rate as may be prescribed and compensation in the manner as provided under the act from the promoter if he fails to comply or is unable to give possession of the apartment or plot as the case may be in time. Uh, uh, the uh, the discontinuance, it can be discontinuance of business developer on account of suspension, revocation, or of his registration. He is entitled to refund. The allottee shall be entitled to have necessary documents and plans, as we have already discussed. Every allottee who has entered into agreement or sale to take apartment, plot, or building, as the case may be, under Section 13, shall be responsible to make payments as agreed upon in the agreement. He is also responsible for payment of registration charges, municipal tax, water, electricity, and maintenance charges, etc. Ground rent, lease rent, whatever is the case may be. The allottee shall be liable to pay interest at such rate as may be for every delay in payment towards the purchase of the flat. His obligation and liability may be reduced when mutually agreed between the promoter and the allottee. I mean, the delay in payment can be worked out between the two parties. Then RERA will not indulge. Every allottee of apartment, plot, building, as the case may be, shall participate towards the formation of society. Every allottee shall take physical possession of the apartment, plot, or building, as the case may be, within a period of 2 months from of occupancy certificate issued for the said apartment, plot, or building, as the case may be. Every allottee shall participate in registration of conveyance. Now, there was one question. You can also see my blogs on my website, shrutidesai.in. Many a times what happens that occupation certificate doesn't come. And no, people ask me, shall I go and because the flat is ready, I occupy? I said, no, don't do this mistake of occupying a flat without occupation certificate. You may land into trouble, and there are several orders also of RERA. So don't violate laws. Laws are, till it doesn't touch you, you don't feel the pain. But once the law touches you, it is very scary, and you will have mental and financial problems. So don't land into problems just because you want to save the rent or whatever it may be. But don't violate the laws, and all the laws regarding possession, right from promoter to possession, it should be followed appropriately. Now, I just want to say one thing. Poonam Chambers, it fell because a beam was removed, and then law came that 20 years the builder will be responsible. I would say that even flat purchasers need to be very careful. There are many cases of collapsing buildings, and people have died of no sin of their own. Do not indulge into internal major alterations. It's a very dangerous practice because you are damaging someone else's property. This law is not there, and I hope our lawmakers takes cognizance, because bylaws of the society in Mumbai, in Maharashtra, permits internal alterations, and even BMC law permits internal alterations to a certain extent. But removal of walls and extension, it should be taken very seriously by the corporation and by authority. And we need certain regulations and check and balances and some competent authority who would, permit such internal alterations to a serious extent. I hope someone is listening to me and think over it, because it is, not me who is damaging the property or removing of walls or shifting of walls. They say, architects say that it doesn't affect. I'm not on affecting it. Today, if I get a fracture here, it takes 3 months or 4 months to recover, So these walls are also something like that. It is constructed for a purpose. And if you disturb it, see, we are living in a cooperative society. It is very limited, rights we have as a member to go and fight, because nothing will happen. It is my also experience. I've also experienced. Nothing will happen, and it gets over. And once it gets over, nothing can be done. So I request the lawmakers to take cognizance of this aspect, because towers are very huge and it can collapse if the walls are tampered with. So we need some competent authority to permit such internal alterations after construction is over. Now, if time permits, I don't know whether time is there or not. Shall I continue with any landmark judgments? Uh, every law in India goes through, very deterrent scanning of the judiciary. This law was also challenged. And Bombay High Court, in the matter of Neel Kamal versus Union of India, where certain sections were challenged, has held that 2 or 3 parties had gone into challenge, and it was held that Bombay High Court held that provisions of Section 46(1)(b), to the contrary to Section 45 of Rera, Article 14, and the principles set down by Apex Court in the case of Madras Bar Association, and it was declared ultra vires. In the same matter, it was held that Rera is prospective. Then state-wise landmark judgment is West Bengal had framed their own law, which was struck down by Supreme Court in the matter of Forum for People's Collective Efforts versus the state of West Bengal and another. They had some act like West Bengal HERA, which was repealed or annulled by the Supreme Court by Pioneer Urban Land and Infrastructure Limited versus Union of India. In this, constitutional validity of insolvency and bankruptcy court was challenged, and it was held that amendment is proper. And there is another judgment of Imperia Structures versus Anil Patni and another. And there is no bar to Consumer Protection Act. You can also see that just because there is a RERA, you can you also choose your forum, either Consumer Protection or RERA. It is within the choice of flat purchaser where he wants to go. And there are many other judgments, but it is now too much of time I have taken. And before winding up, once again, I thank the RAMNARAYAN College, THAKUR RAMNARAYAN College management and the principal and all the students to listening to me, giving me this opportunity. And I also thank my digital team of Margik Bakshi and his team to align and streamline all this live relay of this program. I hope you have understood and enjoyed this 1.5 hour lecture. I have taken too much of your time. Thank you very much.
Hello, ma'am. Ma'am, there are a few questions if you would like to answer them. Yeah, ma'am. So one question is, can stilt parking be separately registered?
No, it is, there is a judgment, and the circular itself says that you have to mention it in the agreement itself.
Okay, ma'am. And one more question from the Pankaj Roy. Is conveyance part of RERA?
Conveyance prior to RERA is not part of RERA, but if your building is not conveyed after enforcement of RERA, being an ongoing project and registered under RERA, then conveyance, of course, you can complain to RERA. There is a judgment. This
Okay,
clarification is given by RERA itself.
Okay, thank you, ma'am. Now, I would like to conclude the session. Thank you so much, ma'am, again for such a great and informative session. I'm sure we all students have learned a lot today. On behalf of Thakur Ramnarayan College of Law, I am grateful to have been given this opportunity to thank our esteemed guest speaker, Advocate Shruti Desai, ma'am, for this wonderful guest lecture. Thank you so much, ma'am, for taking out your valuable time and sharing with us your expertise on such an important topic. I would like to thank our beloved principal, Dr. A.K. Singh, sir, and also our teaching and non-teaching faculty members for conducting such a productive session for all the students. I once again thank all the participants for joining us today. Hope to see you all in our upcoming guest lectures. Thank you and have a great day.
Thank you.
Now, all the attendees, thank you, ma'am. All the attendees are requested to fill the feedback form given in the chat box. Thank you.